Counsel, the prosecutor for the Public Prosecution Service of Canada, Mr. Sebastien Lafrance. Greetings, sir and ma'am. Welcome to both of you. Welcome to all the respected faculties joining in, my member colleagues, and all the participants joining in from every region. I hope that everyone is safe, sound, and well. And we've gathered today to listen to two of these marvelous speakers on the topic of pendency of criminal litigation in India and Canada, and how and why the pandemic has complicated things in this particular process. Moving on with a brief introduction of the speakers. Firstly, we have Professor Bedi. So Professor Bedi is teaching at the University of Institute of Legal Studies at the Punjab University. She teaches constitutional law, comparative public law, internal security law at the university. She's also the director for constitution and public policy at the Institute of Legal Studies. Additionally, she's also appointed the faculty chair at the ADR and the client counseling board of the university. Many of us know Professor Bedi as an eminent TEDx speaker. I would request the participants to just mute. So yeah, and has expertise in counterterrorism laws, and she has renowned publications in that field. Moving on with our second speaker for the day, Mr. Sebastien Lafrance. As spoken, he's a Crown Counsel, the prosecutor for the Public Prosecution Service of Canada. He was a part-time professor of law at the University of Ottawa, and Mr. Sebastien has also worked as a counsel for the law branch of the Supreme Court of Canada. He has published many book chapters and articles in Australia, Canada, France, India, Indonesia on various facets of law and subjects of law like criminal law, constitutional law, international trade, energy law, and so on and so forth. And he is also one of the finest mooters, and he won the first international position at the Charles and Russo International Moot Court Competition. It is not disputed to say that he's truly a hyper polyglot, as he holds commands over many languages. So today, as we all know, that COVID-19 has forced courtrooms into near stasis and shutting down the ongoing litigation and near cases. And eventually, of course, some litigation has, of course, shifted to the virtual procedures and mode. But the inherent challenge of arguing a case purely on a digital platform presents its own challenges and has its own impacts. And most of the litigators in today's time think that COVID-19 had significant impact on their compensation pay and many other things. And they truly feel that the practice of law is it is an art, and the in-person litigation is much better and effective than a virtual proceeding, because as lawyers and as prosecutors or as any party has to satisfy and convince the court and the judge, and henceforth there are many such complication issues, and that's why we have this interesting topic, and we would love to hear both of the speakers today on this particular topic. I would now like to call Professor Shruti for delivering the welcome address.
Thank you so much, Nilang. On behalf of Unitedworld School of Law, Karnavati University, I extend warm welcome to today's eminent guest speakers, esteemed Professor Dr. Shruti Bedi, ma'am, and Honorable Mr. Sebastien Lafrance, sir, to this webinar. It is indeed our distinguished pleasure to have you here as a panelist. I welcome all the participants joining in from different regions of India and Canada. We are glad to have your presence here to be a part of the deliberations to understand the legal systems of two different jurisdictions. Thank you so much. Without further ado, I would request Nilang to proceed further.
I think we should, the topic are such that we should now, begin with the session. I may now call Professor Dr. Shruti for the session. Please, ma'am.
Thank you so much, Mr. Nilang Soni. It's indeed a pleasure to be on this platform. I hope I'm audible and there's no problem.
Yes. Yes, ma'am, you are perfectly audible.
I would like to thank Dr. Brahmbhatt on our behalf. Both Sebastien and I have been eagerly looking forward to this lecture today. And I hope we are able to satisfy the appetite of the students of this university by our talk and by comparing the issue that we are going to discuss today at hand. And as always, it's such a pleasure to be talking with my friend and colleague, Professor Sebastien Lafrance. I would just like to share the screen for the PowerPoint presentation, and please just let me know if it's visible to you.
Yes,
It
it
is
is visible.
Yes.
Okay. So the topic for today, as Mr. Soni has already shared with you, is the part where we discuss the issue of the pandemic and how it is impacting the criminal litigation cases which are pending both in India and Canada, and how the pandemic is making it even worse, how the situation seems to be getting out of hand. And it is really time to pull up our socks and take note of this particular situation so that we can go ahead and find solutions which are not only viable, but for the long run, they should be practical solutions so that we can, at least for the Indian aspect, we are able to, reduce the mounting pendency of cases in our courts, in our country. As far as the criminal process is concerned and the criminal justice system or the criminal justice jurisprudence in India is concerned, we will start with the aspect pertaining to the Constitution, and particularly as far as the fundamental rights are provided under the Constitution, we do not have a particular fundamental right which is designated to the right to a speedy trial. However, in 1979, the Supreme Court of India held that the right to a speedy trial would be considered to be a fundamental right under the right to life and personal liberty under Article 21 of the Constitution. Now, this has been interpreted widely, and why this issue arose primarily was for the reason that there was a mounting pendency in the cases. And especially when we look at the criminal cases where the accused who is undergoing the trial process is under arrest, he's kept inside the jail, and he has to wait for so many years before he can be, the court can pronounce whether he is innocent or he is guilty. And therefore, it is imperative that a speedy trial becomes the basis of our criminal justice jurisprudence. And this long delay in the disposal of trials and cases has a huge negative impact on the victim as well as the accused, because he is undergoing the trauma of being inside a confined environment along with other people who are probably convicts and are hardened criminals. So it's not a good influence on a person who may ultimately be declared to be an innocent person. And in any case, I stand by the age-old adage which says that justice delayed is justice denied. So speedy trial is imperative, not only before, but even more so in today's times. And another part which we also take into account is that prisoners, keep, like I shared with you, that the under trials keep languishing in the jails. So it not only affects their own lives, but their families, because once you are inside the jail, even if you have spent a good number of years or a good number of months, the society treats you like a convict. Even if you are released after being declared innocent, it is not the same. And you never go back to leading a complete normal life. And that is why it becomes even more important that the trial of any criminal case takes place in a speedy manner. Now, before I go into the pandemic aspect, I would like to talk about the general causes for delay in trials. Now, as we are aware that our courts in our countries are hugely overburdened. India is one of the most populated democracies. And to keep up with the number of people, the courts have been failing in this aspect because of the caseload, the number of cases which are being filed, and the difference between the number of cases filed and those that are able to be taken up and are decided ultimately. So the caseload on every judge is huge, and he is not able to do justice to his assignment. Moreover, because there are so many cases on a daily basis in the courts, judges are probably more willing to adjourn the matter very often, leading to even more delays in the entire decision of the trial. The second cause which we have is the testimony of witnesses, which is extremely detailed, and we are not able to catch the crux of the matter. We can say that we don't have seasoned interrogators who can really cull out the exact point which is of relevance to the matter. So long testimonies which are running into pages, or which actually end up wasting the time of the court, are not really the ideal way to go about the situation, and therefore we need to have specialized people who are dealing with such witnesses and able to extract the pointed information which may be relevant to the case at hand. In India, a very peculiar problem that we face is that witnesses are generally unwilling to come and appear in court. And if you, as Indians, you are aware of the whole system, because the moment you're called or summoned as a witness, you are not happy going. Why? Because the moment you reach the court, there is complete chaos. The witness does not know where to go, how to go about it, and wastes a lot of time in really generally deciphering the whole process. Number two, the payment which is made as a travel allowance to the witness is not particularly handsome and satisfying, whereby the witness would be willing to come again and again. And because there are general delays or adjournments, the witness may not be able to give his evidence during on that day. So he may have to come again and again. And that means giving up his work on a daily basis for a long period of time, which generally people are most unwilling to do so. Adjournments, I've already told you, are more likely to be given by judges because they want to reduce their caseload. And the most important factor in the mounting number of cases is the inadequate number of judges that we have today. Whether we talk about the Supreme Court or the High Courts or the lower courts, the situation is the same. The number of judges proportionate to the population, proportionate to the number of cases that are being filed daily, are completely inadequate, which means that the cases keep mounting and the decisions are not able to keep pace with the mounting workload of cases. Then we also have the legislations which may not be explicit, which may not be clear. So any kind of drafting mistakes or anomalies in the legislation itself means further delay. Sometimes the accused is absent from, there's the opposite party is always trying to ensure that the accused is not produced in the court, so that there is delay and the case loses the steam against the, in whatever manner that you want, how you want to play it. So the politics which is involved also adds to the delay. Now, and part of the police, the investigating agencies, there is a lot of, laxity in the investigation process. There is delay in the framing of charges. The investigating team is not able to make use of the new modern scientific tools at the disposal of such experts. You do not have good number of forensic experts. You don't have other experts. They do not use scientific tools, because all this will reduce the time and will make the case more effective. So this is generally adding to delay in cases. Now, before I come to the pandemic, this is what I wanted to talk to you about. And last year in March 2020, the pandemic came to the world. Of course, it came to the world before that, but generally from March 2020 onwards, the lockdown was imposed in almost all countries of the world to deal with this. And one of the systems which was hugely impacted was the judicial system. It was impacted in all countries, including India and Canada. And immediately the courts in India came up with certain orders and directions because physical hearing was immediately suspended. Uh, the courts were closed for the time being of the lockdown because what was paramount as a consideration was the safety of lawyers, the litigants, and the general public. So the hearings had to be suspended. The court only started taking up really, really urgent matters. And there was a time there were no cases that were happening in India, at least in the Supreme Court, if we're talking about the apex court in the country. And if there was a mentioning which had to be done, it was to be done before the mentioning officer. And the Supreme Court already had a system of e-filing of cases. However, that had probably been underutilized till March 2020, as with the other high courts and the lower courts. But suddenly, after 2020, after the declaration of the lockdown due to the pandemic, it had to be taken up more effectively. So e-filing was offered as an option. And of course, then they allowed cases to be conducted and argued through the means of video conferencing through various sites. And importantly, the Supreme Court of India extended the period of limitation of filing cases. So, if your period of limitation was to expire during the lockdown, the Supreme Court of India ordered that all cases with a limitation period would now be allowed to extend their limitation period till March 2021. So that was another, stand or order which was made by the apex court. Now, as far as the high courts were concerned, similar directions were issued by most of the state high courts, and the lower courts also followed suit, and only extremely urgent matters of where they needed bails or urgent criminal proceedings which could not be avoided were taken up. They wanted to avoid conducting trials. They wanted to avoid the accused or the under trial being brought before the court, so as to minimize the number of people, the human footfall in the courts. So this was what happened immediately after the declaration of the lockdown during the pandemic. Now, coming to the crimes which started happening because of the lockdown, there was a general decrease in the crime rate, but there were certain crimes during the pandemic which generally shot up. So there was counterfeiting and fraud. For example, the industry relating to the masks and sanitizers and PPE suddenly there was a lot of fraud being played in that. And recently, during our second wave of this pandemic, we also saw people hoarding oxygen cylinders because that was a shortage during this time. So counterfeiting and fraud picked up during this time. Cybercrime, because everything was happening online. Now, obviously, the cyber criminals had a whale of a time during this time, and they were hacking into various sites and various meetings of the government. And there are so many incidents of, even the government trying to tackle the problem of cybercrime. In fact, recently, all across the world, we've all heard of the issue of Pegasus, the spyware which has hacked into the mobile phones of not only ordinary people, but prime ministers and presidents of important countries, including France. Mr. Macron has had to have his mobile phone also open to this kind of a spyware technology. Another kind of crime that we saw really increase, and that was the increase throughout the world, including Canada and India, of course. This was domestic violence because people were cooped up inside their houses. They were, in fact, living with the person who was committing the violence and with no way out. So domestic violence as a crime really increased. Terror attacks. India has had to recently deal with a lot of terror attacks, including drone attacks. And from January 2021 till May 2021, we have had counter-terrorism, the 28 counter-terror attacks to somehow stop the terrorists from organizations from spreading their wings. So these are the crimes which generally increase during the pandemic. Now, talking of the pendency of cases, as of 15th of April 2021, in India, there are 4.4 crore cases which are pending in our country. Now, you can imagine the state of affairs that we are dealing with, where it has, this has gone absolutely out of hand. And the Niti Aayog, which is the prime government body dealing with the governance and its reforms, says that it's going to take 324 years to clear this backlog. I don't know. I mean, of course, we are not going to be alive to see that day, but we really need to come up with a solution fast to get over this problem. I'm going through the slides quickly. I'll share the PowerPoint with Dr. Brambhatt so that he can share it with the students, because I don't want to overstep on to the time that Professor Sebastien will be taking. So anyway, talking about the pendency problem, why this has happened is because in India, especially taking into account the lower courts, which are there in the rural areas, in the villages or the districts, where technology has not really taken flight. So not only the people who are illiterate, who are poor, but also the courts are unable to keep up with the the modernization of the technology and its use, especially during this pandemic problem. So if you notice, the Supreme Court has handled it the best because they have the best facilities at hand. And not only that, the lawyers who are appearing in the Supreme Court are usually more tech savvy as compared to the others. High courts have more or less also stumbled to keep up. But the problem really lies in the lower courts where the criminal trials are taking place. And that has become a huge problem in this whole system during the pandemic because of the digital illiteracy of the people and the courts, leading to the increase in the pending cases, especially the criminal matters. The courts also try to adopt other methods to reclassify matters, like decriminalize check bouncing. But, that comes around through another kind of, it's maybe filed as a case of cheating or, another matter. So it's not that the case goes away. It comes through another medium. And interestingly, the Indian jails are more full of the under trials who have never been, there's not a decision which the trial has reached, whether they are innocent or whether they are guilty. So they have been languishing in the jails for so many years. It is unfortunate, and this adds to the problem of the pending criminal cases. Of course, the pendency in the number of judges which are appointed is also the bigger issue here. But coming to the issue of virtual courts and why the pandemic is contributing to the increase in the criminal cases is, number one, the virtual courts which have come up is leading to the demolishing of the open court principle. Open court is basically where the members of the public can come and watch the proceedings. And like somebody said, that sunlight is the best disinfectant. So the public is the best judge of how the court is proceeding, how the case is proceeding, and whether the justice is being done. But when we talk of virtual courts, this principle of the open court is done away with, and that is a huge setback to our system. If we talk about the access to justice, just a minute. Is my slide visible to you? Okay. Now, yes, I would like to also talk about a very important case and judgment of the Niresh Sridhar Mirajkar case of 1967, where the Supreme Court particularly had held that the open court principle is very important for a healthy, objective, and fair administration of justice. And this principle needs to be followed throughout the country. And as far as criminal trials are concerned, this becomes even more important. Now, of course, the open court principle has been, kept on the back burner when we talk of virtual courts, and this the Supreme Court has allowed through its powers under Article 145, Clause 4 of the Indian Constitution. There are also provisions under the CRPC, that is the Criminal Procedure Code, and the Civil Procedure Code, which allow this. So this power has been, used accordingly. Now, the other, in fact, Professor Sebastien may be talking about this open court principle, and I would like to mention a case from the Canadian Supreme Court of the Vancouver Sun versus the Attorney General of Canada, which holds a similar view, which was held in this Naresh Sridhar case in the Indian Supreme Court, where the Canadian Supreme Court said that openness is a principal component of the legitimacy of the judicial process. So this is an extremely important part. But however, moving on, the other challenges to conducting the proceedings of the court online, especially in criminal matters, is the accessibility to justice, because justice is not accessible to most of the people. In India, internet is not available to everyone. In fact, 72% of the people have no access to the internet. Now, as far as the demeanor of witnesses is concerned, one of the important ingredients of cross-examination or examination in chief is how the lawyer is able to conduct the examination of the witness by looking. It's very important for the lawyer to look at the facial expressions of the witness so that he's able to gauge how to proceed and what is the response and reaction of the witness. Now, that is not possible as in the same manner as it is in the open court. So the virtual courts do not allow you that liberty, because sometimes there is a time lag between a question which is asked and when you respond. And there are technical glitches which again lead to problems. And many times we see that false evidence may be recorded. Now, in a recent case of state of Kerala versus Rashid, this was pointed out actually that it was held that cross-examination is the greatest legal engine which has ever been invented for the discovery of evidence. So that is being lost in the system of online proceedings. Another aspect which really suffers is the lawyer and client interaction. Because of the virtual mode, it is not as effective as meeting face-to-face and discussing everything. Documentary evidence has been a problem, because uploading documentary evidence, showing it, or even making it accessible as a PDF file is not the same thing as when you need to see it actually, especially in criminal cases. Now, another important aspect which I found was extremely relevant here was that, one thing which acts as a deterrent to any person to commit a crime is the punishment which is awarded to him. So he's scared that he's going to be punished in a particular manner. Along with that, the communicative theory of criminal jurisprudence says that it is not only the punishment which is important, which acts as a deterrent, but it is the manner in which it is communicated to the accused, the manner in which the judge censors him, the public looks at him in the open court, and he is made to feel that he has done something wrong. So the ordering of the punishment, the conviction of the person, and the awarding the punishment to the accused is a very, very important factor in future deterrence, which is extremely effective in the open court, but not so much in the virtual court. So these are the issues that we have been dealing with in the online proceeding system. And of course, now, because of the online proceedings, you have a huge matter and problem of identity theft. Because, in the open court, the litigant identifies his lawyer, the lawyer identifies the accused, and so on and so forth, but it is not happening in the same manner in the virtual court. So these are the problems that we are finding that it has led to further problems and increase in the pendency of criminal cases in India. Of course, many measures have been undertaken like e-pay, e-summons, e-hearings and e-judgments, and there was a 24/7 digital window which has been opened, but still we find that there is a mounting increase in the pendency of cases, and that is primarily on account of the digital divide and the digital illiteracy that we have amongst the majority of the population in India. So Supreme Court has also, with a view to not overcrowd the jails during the COVID pandemic, says that don't arrest the accused or the person who's going to undergo the trial unless and until it is absolutely necessary. And recently, during the first lockdown and the second lockdown, the Supreme Court ordered the decongestion of prisons. They let out people on parole so as to reduce the number of people inside the prison, so as to reduce the spread of COVID inside the jails as well. So this is my few points that I wanted to share with you, and I hope you have been able to take something from it, and I look forward to our question and answer session. I don't want to exceed the time. I mean, I have overstepped a little bit, but I'm sure that Sebastien will be able to make up, and looking forward now to hearing Professor Sebastien.
I mean, ma'am, the points that you draw are very pertinent and wonderful. And the things that you told, actually, pandemic has made the judiciary and the legal system to think on many facets. Like there was the recent incident that although the 66A, Section 66A was struck down in the Shreya Singhal case, but still there were thousands of complaints being filed in that particular case. And then we saw that the order of remand or the release of the custody of the prisoners is being sent by the courts to the prison cells by post. They are not being uploaded on a particular website. So Supreme Court, the e-digital committee led by the Honorable Justice D.Y. Chandrachud also recommended that there has to be a particular procedure and a website where they can upload that particular thing. So of course the pandemic is open that particular facets and challenges to be undertaken for the same. So actually, questions would be questions would be dealt by in the last few minutes of the session, if that's fine with you.
Absolutely.
So we can hear Mr. Sebastien. That's why. So we are all used to hear you, sir.
Yes, good morning, everybody. I just would like to confirm with you that you can see my screen right now and my PowerPoint.
Visible, sir.
Excellent. So it is a sincere pleasure to be with you this morning, and also to co-present with Professor Bedi, who I consider to be a close friend of mine, if I may. And our explanations will actually, they are interesting in and of themselves, but you will see also that there are connections to be made with the Canadian reality. So before I start, I'm just gonna do a little waiver. Everything that I will be saying this morning, it's only on my behalf, my personal behalf, and not on behalf of my job, the Public Prosecution Service of Canada. And it's not binding on my workplace or the Government of Canada or the Public Prosecution of Canada. So just to make a quick preamble about the topic today, why do we talk about Canada and India? I will not focus on this. I published on the topic, and I really take great care when I publish in India to make the point, or talk in India, to make the point every single time I can. Canada and India share a lot of things from, of course, from various aspects of life, but also from the legal perspective. It is, I will not make an editorial point, but it is surprising that both Canadians and Indians are not citing more each other, especially in the criminal law field, where we share so many things in common. We inherited from the British tradition, legal tradition, in criminal law, and that would be way more interesting. And that's why I find my collaboration with Professor Bedi so fruitful, so interesting. It's because not only because Professor Bedi in of herself is a dwell of knowledge and science, but also because it's interesting to compare our countries because they share so many things in common. So you will see this morning, again, talking about the delays that are incurred, especially with a focus on the pandemic, but I will explain to you the basics of Canada, that there are some, yes, there are some similarities and differences. One cynical person could say, yes, there are similarities and differences with everything. So it doesn't mean India share so many things or with Canada. Well, for that aspect, I will not argue it. I will simply invite the attendees to read my piece on this issue, where I demonstrated I believe that India and Canada have a lot in common. So to basically, let's start with a difference. In Canada, the protection for the accused to have a trial within a reasonable time is provided by the Canadian Charter of Rights and Freedoms under Section 11B. So it's not basically a red-end process as it was in India, as Professor Bedi pointed out, with Article 21 of the Constitution that does not provide it directly, but it was red-end somehow with a decision decided to basically provide it to the accused as a right, but it is directly provided in Canada with a section of the Charter of Rights and Freedom, which was enacted in 1982. So it's not so long ago, but this is taken very seriously. So this evolved, actually. There is one decision of the Supreme Court of Canada that we will not discuss this morning, which addressed delays before the decision that is the Jordan decision that is referenced on the screen right now at the bottom of the page. Of course, it was discussed way before 2016 by the Supreme Court of Canada, but that decision made a huge change in Canadian criminal law in terms of delays. It changed the culture, and we'll see why in a few moments. So just to illustrate the impacts, of course, Canada is 35 million population, I believe, or something like that. So it has nothing in comparison in terms of the population width of like nothing in comparison with India at all. India, as Professor Bedi said, is one of the most, if not the most populated democracy in the world. So Canada is way smaller. However, delays in criminal trials still affected seriously the caseload and the workload and the courts, et cetera, et cetera. So in 2016, more than 800 criminal cases have been stayed. So that includes murder cases. So the various serious cases have been stayed because of delays, because the rules have not been complied with, and we'll see them some early this morning, the rules that apply in Canada. So that's very serious. I included on this, the picture is meaningful here. This is the famous Dali painting about the watches and everything. So basically time flows and time melts, but here delays is of the essence, and delays are important to be scrutinized and looked at and be cared of when preparing cases. For example, and that's something that Professor Bedi touched upon briefly, and I will come back to that immediately, when she mentioned basically the case management. And as a prosecutor myself, I can tell you that this is something that will be taken into account and consideration seriously when preparing cases for court. For example, practically, if I am calling 20 witnesses for a case, how much time is it going to take? Are all these witnesses essential for a case, or I'm calling a few people just for the narrative and they're not essential? because when you call witnesses to testify, it takes time in court, and then it takes time to prepare, and then it takes time for the evidence to be collected, to be gathered, and then it takes time for the investigation to be done. And when charges are laid in Canada, and we will see it with the Supreme Court of Canada decision in Kalanj, Kalanj, we'll see it in a slide, no worries. So this is where the clock starts ticking for the delays in the calculation of the delays. But let's not put the cart before the horse, but the same idea, the same notion that Professor Bedi mentioned for India applies in Canada. So case management and the ways, actually, this is very key. The way prosecutions are made now, since the Jordan decision, since how delay is calculated, has changed. And we will see this morning that COVID also added a layer of complexity to it. So this is what makes it interesting, but also makes it complex. So to illustrate, so the decision of Myers of Supreme Court of Canada in 2019 identified the existence of really a pre and post Jordan era. So Jordan is a decision that was rendered by the Supreme Court in 2016 that denounced basically, and I put the most relevant quote here, not in terms of relevancy. The entire decision is relevant, actually, to be honest with you. It's a very important decision in Canadian law, criminal law. But the Supreme Court of Canada and Jordan denounced the culture of complacency. So basically, before, what happened was that the adjournments, the way was done, the way was calculated, delays, not saying delays were not important, they were, but they were calculated in a way that was a bit more flexible, which led to the Supreme Court of Canada, and using these very strong words, and the Supreme Court of Canada weighed these words, of course, when stating it. So they denounced the existence of a culture of complacency when it comes to delay. So it had to be taken very seriously. So what is so important in Jordan is the Supreme Court of Canada decided to impose ceilings, so threshold that should not be that must be complied with in terms of delays. So before, and we'll see when is the beginning of a case for the calculation of the delay, and also the end of the case, how it is calculated. We'll see it on the next slide, explained very summarily and clearly. But basically for provincial court matters or Superior Court matters, it's respectively 18 months and 30 months that is the ceiling. So beyond that, beyond 18 months for provincial court matters or 30 months for Superior Court matters, this is where the delay will be considered or may be considered unreasonable unless it falls under two exceptions, two categories of exceptions that we will see today. And one of these exceptions is impacted directly by COVID, actually. So this is why this topic is interesting. So to make it clear for the Indian audience, provincial court matters, it's for more simple, between quotes, the simple matters or easier matters, not necessarily less serious. There are certain categories of offenses which will not be prosecuted in provincial courts, like murders, for example, but Superior Court matters or for all matters. This is, if we refer to the Constitution of Canada, this is a residual court. So all matters can end up in the Superior Court at the first instance, but usually this is for more serious matters, between quotes, for more serious, because all matters, all criminal matters are and have to be taken seriously. So this is a presumptive ceilings. So very briefly, this ceiling of 18 months also apply to provincial offenses. And why do I mention that? It's just to show you that delays, it's not only important for big drug trafficking cases or murder cases, it is also important for offenses of lesser importance, or should I say, still not saying that these offenses are not important, but for a highway traffic act or liquor licenses. So all offenses, most offenses are affected by delays and by the calculation of delays and the ceilings that are imposed by the Supreme Court of Canada. And also same for youth court, the youth criminal justice system. So the youth offenses are also impacted by, have to take into account delays and the ceiling that was imposed by the Supreme Court of Canada in the Jordan decision. So here, when does it start? When does it end? How do you calculate the delay, Seb? Like, because what you're telling us right now, it's not clear. We don't know what you're talking about. I will be clear. Let me clarify this. So when the trial starts, or the clock, actually, not the trial, I'm sorry, but when the clock starts ticking is when the charges are laid. So as soon as there could be a 1 year, 2 year investigation before charges are laid, this is not counted. Supreme Court of Canada and the Queen versus Kalanj told us that the starting point is when charges are laid. And when does it finish? When do we stop calculating the delay? When, for example, an accused would like to complain and make a file a motion to Jordan motion, Jordan application, as we call it in Canada, in order to challenge the time it took to the Crown to bring the matter to court for a trial. So the 11B, the relevant section of the Canadian Charter of Rights that applies. So the Supreme Court of Canada decided recently, a year ago, actually, it was last year in 2020, in the decision KGK, stated that yes, it stops basically after the end of the evidence and the argument are made. So the presumptive ceilings do not apply, because before then it was unclear, and there was conflicting jurisprudence, conflicting case law in Canada as to how do you calculate the delay? Does it apply after the trial is done? Does it apply after the evidence is called and finished and completed by the Crown and defense, if there's counter evidence to be called? So it was not clear. So the starting point now is clear when the charges are laid, and the end line, the finish line is clear. It's when it doesn't go beyond the end of the evidence and the argument are made in court for the trial. Some other considerations, basic considerations in this long preamble. Let's not forget that, just one point quickly, Supreme Court raised it in the decision, the Queen versus Vassell, that the delay is not necessarily the same, right? Because when we have multiple accused. So this is something to keep in mind. And the same applies in India, same idea, same notion. So if you have several accused, but an investigation for one accused, it was super easy, for example, because, well, he was seen by 10 people committing the offense, but there's a co-accused in that case, let's say in a robbery case or a theft case, where somebody steals a car, the driver of the car, the accused, was seen by 10 people, but he's got an accomplice, and the investigation for the accomplice took 6 more months. So that delay, how do you calculate the delay? So this is for both of the accused, separately, jointly. So these are all things to be taken into account. We're not going to delve into it because I want to focus very, very soon on COVID, but I wanted to give you this preamble before. So in order to rebut the presumptions of the ceiling, so the deadline, so the 18 months or 30 months ceiling, the threshold that if you go beyond it as a Crown, or as the case, if it goes beyond that point, this case may be stayed, may be thrown out in the garbage, actually. So there are 2 exceptions that basically say, no, this presumption of 18 months or 30 months will be rebutted. So there's the first one that we will not talk about because it doesn't apply with COVID directly, at least, maybe indirectly, is when cases are complex. So when cases are complicated, very complex, and we're not talking about the complexity, that it has to be defined. It's not just because, oh, it gives me a headache tonight, my case is complex, I will ask for an extension of the time. This is not how it works. But this category, we'll leave it aside for this morning. What I would like us to focus upon, and which is very interesting, both for, of course, for Canada, but potentially also from an Indian perspective is the exceptional or discrete circumstances category. So this is a category that basically it's for unforeseen or unavoidable circumstances for which it cannot be reasonably remedied. So COVID, as we all know, and as Professor Bedi mentioned earlier, COVID had the impact of having court closing for public protection, for the protection of judges, for protection of everybody who was attending court. So this, by default, extended delays in and of itself. This is one of the impacts. So certain dates, and it's not necessarily what's interesting here. It's not the idea to challenge whether if a COVID would be an exceptional circumstance or a discrete event. It is, of course, it is. Never happened since decades such an impact of a pandemic. There were pandemics before in the history of the human race, but with an impact like this in the court system, at least in recent times, it's unprecedented, at least recently, unless we go back way back when. So there's no point to challenge the fact that it is exceptional. It is an exceptional circumstance. But what is interesting here, that's what I pointed out here. So that's been acknowledged by the court. Let me just say that very briefly. Courts acknowledge very easily, very quickly, actually, in the process, that COVID it was a discrete event. It had an impact on the court system. It slowed down the court system. And it has an impact, obviously, on the delays that was incurred because of the closing of the court system and for various reasons. So under the Jordan framework, so again, to go back to the decision, but still with a focus on COVID here, if we go back to the Jordan framework that was decided by the Supreme Court of Canada in 2016, there are two things that must be, there's a test actually that applies in order to qualify the delay and calculate the delay in terms of exceptional circumstance. As we saw, the first one is easy to meet in this case. Is COVID a reasonable, unforeseen, or unavoidable? Yes, it is. There's no way it could have been avoided or foreseen before. There's no way somebody can say, oh, Mr. Crown knew there was a world pandemic coming, or Madam Crown could have known that. Of course not. There was no way Crown could have known this in advance in its prosecution of a case. Same for Canada, same for India. But what is interesting here, because of the impact of COVID, is the second point of this test. And the notion itself, I don't say the decision applies mutandis to India, but it's still the notion itself that would be very interesting and very fruitful food for thought to reflect about this further, and if somebody would be interested by making a comparative analysis. But this would be interesting is the second point. Even though it's not in the Indian case law, the Indian jurisprudence specifically, in that context, I checked, believe me, but we have this point of could the COVID have been reasonably, is there a way to remedy it? So is there a way to reasonably remedy the delay? Usually this test is met in Canada on a case-by-case basis. So the judge will look at the actions that were taken by defense of the Crown. Actually, of course, when it's defense delays are counted in order to see if the delays are not caused by defense. In order, for example, not always the case. I'm not saying it's always the case, but is it to basically create an issue of delays with the Crown, etc., or did defense took all reasonable steps in order to? And did the Crown also take all reasonable steps to move the case forward? But how can you do that when it's COVID and it's systematic? It's systemic. It's not a case-by-case basis. So, for example, let's say one of the witnesses falls sick, not of COVID, falls sick of something else, whatever, cannot attend court on the day was supposed to testify. the matter must be adjourned if it was the only witness, or the matter must be adjourned, it must be added to a list of witnesses later on. That's one example. And then there is a delay in calling the evidence in court. So that's one example of many. Somebody breaks his leg, must stay home, whatever, or there's some institutional problem, even electricity outage that happened in one court. The electricity went out, run out one day in court, so the case couldn't move forward, so delay was incurred. But this is case specific, and this is what Professor Pacheco, with whom I did clerk at the Supreme Court of Canada, so it's a very brilliant professor, very brilliant person, but this is what she pointed out. She pointed out the fact that, well, the framework of Jordan of 2016 focuses on a case-by-case analysis, so it uses cases. But here we have, and I'm almost finished here. We have a systemic, a discrete, what Professor Pacheco calls a discrete system-wide events. So COVID affects all the entire system. So could you, how do you remedy it? Because like Professor Bedi mentioned, sorry, like Professor Bedi mentioned, we have video conferencing, so et cetera, et cetera, et cetera. So let's say in an area of Canada, and that's something else that really struck me when that Professor Bedi mentioned, access to internet. Let's say a lawyer doesn't have, or an accused doesn't have money to buy internet, and that argument was made actually in Canada. So there's no internet, and then how can he access court? And there are delays. So there are many issues that here are not necessarily, they can be, but they are not necessarily case by case or case specific. But there are issues that exist because of the bigger event, which basically affects everybody downhill, because it goes downhill because it affects everything. So what Professor Pacheco mentioned that is quite interesting is, so, and that's the first thing I point out when I just talked about. So there are unique problems with the second prong of the test that exists in Canada. There could be problems in terms of how do you apply it to the COVID situation, because COVID situation, it doesn't happen in only one case. It happens to everybody around the world, not only in Canada. India was severely affected, as we all know, by COVID. So this is something that is not, it cannot be case specific. So this test that was created, and this is the argument of Professor Pacheco, is this test of Jordan cannot be in order to rebut the ceiling, in order to say, yes, it took us 20 months, 22 months, 25 months to let's say we are in the provincial court and the ceiling is 18 months and we go beyond that deadline, we take more time. So the COVID delay is one delay. It's one example, but it does affect systematically and the entire system. So it's a system-wide events, not a case event. So how can we, and for the second prong of the test, how do you remedy it? This is food for thought. I will leave it to you to think more, to ponder more over it. But I found it interesting, especially that, like I said, when I started, Canada and India share so many things in common that the Canadian experience could potentially inspire some authors in India, or some jurists and judges maybe in India in that regard. And I will finish on this point very briefly, a few seconds. So perhaps what Jordan wanted to when Jordan, we were thinking, I remember it when it came out, it said, oh, that solves the problem. Yes, it's a harsh decision, it's very hard, but it's a wake-up call for the Crown, for everybody, for the judicial system to address the problem of heavy caseload, of delays, even more seriously, because it was taken seriously before. But this wake-up call by the Supreme Court of Canada, with the denunciation of the existence of the culture of complacency, et cetera, et cetera. So we thought at the time, okay, must cover all situations. But now with COVID, and with what Professor Pacheco points out, maybe it does not. Maybe this legal framework could need to be revisited at some point. So this is food for thought. But this is what I wanted to mention about the impact of COVID. So basically, the entire criminal system is affected, of course, the entire judicial system. So thank you very much for your attention. It was a sincere pleasure, and thank you very much. I didn't thank the invitation and Professor Shruti for the invitation as well. So it's very very nice, and thank you very much. Bahut dhanyavad.
Thank you so much, Mr. Sebastien. Thank you. And after hearing both the speakers, one thing is for sure that the complexities in both the legal system, India as well as Canada, have been in a much more in an increased manner. Like the litigation backlog, the delays that were being emphasized. Probably the courts and the legal system will definitely come up with few of the remedies, but it is a worldwide problem, and we have to go through the same. Now, I would like to open the floor for questions. If anybody has any questions to both of panelists, they can just write the question, or if the connection is stable, they can even unmute themselves and ask to the speakers. Simran Patavri has raised her hand. Please, Simran, go ahead.
Good evening, everybody. Good evening, ma'am. Good evening, sir. My question is to Shruti, ma'am. Ma'am, at one point you were talking about the open court concept. So, to my knowledge, when the pandemic first started and the virtual hearing started in the concept of Indian jurisprudence, at that point of time, the open court wasn't followed that much, since only the interested parties and advocates could attend the meetings. However, when we view it presently, all the court hearings are very well streamed live on YouTube, which allows everybody to access it. Do you think that that solves the problem when it comes to the open court concept?
Thank you, Simran. I think that's a brilliant question which she has raised and pointed out. It is a great measure that the Supreme Court, when the Supreme Court ordered that there should be live streaming of the proceedings of the cases. In fact, it was Chief Justice of India, Deepak Mishra, who had, advocated this during his tenure as CJI. But it is during this time that this has really become force, which then brings into focus the original open court principle, as you pointed out. And I say that in the virtual world, it is something when we are, telecasting the live proceedings, it does make a difference. But still, I do feel that it is not exactly comparable to the original open court principle that we speak of. Because, when the proceedings are actually taking place in the presence of the public, the lawyers, the judges, the accused, the victim, the entire lot of people who are involved in the matter are, conscious of this fact that they are being publicly scrutinized. And they must therefore do their best to ensure that justice is provided. So that public gaze, the sunlight which is coming in, is actually giving power to the integrity of the courts. When we talk of the live streaming, yes, it is there at the back of the mind, but you cannot really see the public, and you cannot, you don't have the same feeling that you are under the watchful gaze of the public, and therefore you are more conscious. So it is indeed a great step when we talk of the virtual courts, because we don't have an option at this point of time. This is the best that we can do, and this is definitely a great step. But nothing beats the actual physical open court, where the public sits and ensures that justice is carried out and it is done.
And if I may add to Professor Bedi's, I know the question was not directed to me, but as a prosecutor, I feel compelled to compliment the brilliant answer given by Professor Bedi here. And I'm sure she will not mind if I add some more items to what she said. very, very accurate and interesting points. And she's right. And I agree with Professor Bedi, not only because she's my friend, not only because she's brilliant, but because she's right.